right, Mr. Manning, good afternoon. Who do you have first?
Judge, this is Brock George.
All right, this is cause number CR 25-268, State versus Brock Albert George. We're set for status of competency and also pretrial. Mr. Manning, is it my understanding that Mr. Brock has been evaluated and has been found competent to stand trial?
That is correct, Judge. He is on medication through the Andrews Center. I spoke to him today. He said some of his medication he feels like is not being as effective, at least in the mornings. So I've explained to him the process of getting an appointment with the Andrews Center so he can get that adjusted and remain competent. I also explained to him that I've requested an offer from the state, but we don't have one at this point in time due to the complaining witness not cooperating with the DA's office at this point. We have no contested pretrial issues at this time. We request to be set on docket call.
And Your Honor, I just want to clarify, it's not that the complaining witness is not cooperating. We just need to have time to sit down and chat and have a full discussion with him.
Understand. All right. All right, court will set Mr. George then for, you said another pretrial setting. Is that correct, Mr. Manning?
No, Judge, we request to move it on to docket call.
Docket call. All right, court will set Mr. George then for docket call on June 4th. Cause number CR 26-22, State versus Edward Joseph Drummond for arraignment. Go ahead.
Judge, Mr. Drummond's name is spelled correctly. He understands the charge against him as well as the range of punishment. His plea is not guilty. He requests to be set on the pretrial docket. Just additionally, Judge, we would request a shorter setting on the pretrial docket. Based on my conversations with the complaining witness, I believe we can get this case resolved sooner rather than later.
How soon is soon?
Judge, do you have a docket early May?
No, sir. I've got next Thursday, and then I don't have anything until the 28th, which is the next evidentiary. I can put you on a Tuesday. I can put you on Tuesday the 12th, but I don't have a Thursday. Judge,
I'm gone on the 12th, but I believe if I have discovery open, I can go over it with Mr. Drummond on Friday, and if the state is willing to make an offer, I believe we should be able to get done by next Thursday.
All right, so you mean just set it tentatively then for pretrial next Thursday?
Yes, Judge.
All right.
Yes, Judge.
Mr. Drummond then for pretrial on Thursday the 30th. All right, Mr. Stevens, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Go over again. Mr. Stevens, you appeared previously before the court, and that was on February 11th of 2025. On that day, you pled guilty to a third-degree felony offense of assault of a family or household member with a previous conviction. On that date, the court heard the evidence and followed a plea agreement that you had reached with the state. And based on that agreement, the court placed you on deferred adjudication for a period of 3 years and ordered you to pay a $1,500 fine. It was during your period of community supervision that the state of Texas has filed its motion to adjudicate and revoke. And in that document, they have alleged 8 separate counts of violations, of alleged violations. Have you had enough time to review that with your attorney, Mr. Manning?
Yes, sir.
Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you understand everything that you have read and signed today?
Yes, sir.
Do you have any questions about anything before we go further?
No, sir.
All right, Mr. Manning, do you believe Mr. Stevens to be competent to enter into this agreement?
I do, Judge.
Does he waive the formal reading of the state's motion to adjudicate, and is he intending to plead true to all counts?
He does and intends to plead true to all counts, Judge. I would point out, though, that while he was on sanctions court, he had partial compliance with registering for BIP, as well as paying off some of the fines and court costs. Unfortunately, he was unable to continue that with the recent revocation that was filed due to the positive test in February.
Thank you, Mr. Manning. And what kind of credit time is Mr. Stevens entitled to on this agreement?
We reviewed that, and the calculation was 147 days, and we agree with that calculation.
Right. Mr. Stevens, then I would ask you at this time, how do you plead to counts 1 through 8? Are those counts alleged true or not true?
True.
And has anyone threatened you, forced you, or pressured you to plead true to any counts?
No, sir.
All right. Then the court will accept the defendant's plea of true to each count as alleged. The court will find that Keith Edward Stevens has violated the terms and conditions of his community supervision. The court will follow the plea agreement today. Court hereby adjudicates the guilt of Mr. Stevens, convicts him of the third-degree felony offense of assault of a family or household member with a previous conviction. The court revokes his community supervision, assesses punishment at 3 years confinement in the Texas Department of Criminal Justice, orders him to pay the balance of his financial obligations, and the court awards Mr. Stevens 147 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Stevens, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you are released from TDC, if you've not already paid off all of your fines and court costs, you will need to report to the courthouse up on the 3rd floor to meet with the district clerk's office about working out a payment plan. Failure to do so could result in a warrant being issued for your arrest for failing to pay fines and fees. Do you understand?
Yes, sir.
All right, thank you, sir. Please step over to be seated. Mr. Hartwell, I noticed that on this judgment, there was not a field available for me to enter in the jail time credit. So I'm not sure what I can do about that. Let's see here, I don't think I can override anything.
Yes, sir. We may have to send a fresh cover sheet with that for the record.
Yeah, I'm trying to figure out how.
Right.
Right. Because if you resend it, Mr. Manning and Mr. Stevens are going to have to re-sign. It's either that or you not, no, maybe not pro-tunc it.
We could do that, Your Honor.
Let's do that. That might be the easiest thing. Any objection to that, Mr. Manning?
Judge, is there a way to possibly print it to PDF and overwrite the signed copy?
Not sure about that.
If not, Judge, we would be fine with nunking it, just for
I'll
to keep
take-
it clean.
I'll try upon your suggestion of the PDF, and we'll see if all the signatures and stuff stay. I think it removes signatures, but I will find out for sure. If it doesn't, then I'll let y'all know. We'll just need to nunk it as a clear.
Thank you, Judge.
Yes, sir.
Back on that, we're off the record. Back on that other issue, Mr. Stevens. Yeah, upon downloading the PDF, it does appear to keep the signatures. So I will just print that off, and we'll have to do a hard copy on this one. So we won't need to nunk pro-tunc. R 24-307, State versus Philip Andrew Ogletree. Mr. Ogletree, if you'll raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, glory. All right, Mr. Ogletree, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you understand everything that you've read and signed today that's in your plea agreement?
Yes, sir.
Do you have any questions about anything before we go further?
No, sir.
Mr. Manning, do you believe Mr. Ogletree to be competent to enter into this agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after having been informed of his legal rights?
I do believe he is competent. I do believe he's waiving his rights intentionally, knowingly, and voluntarily.
All right, Mr. Ogletree, I see here that you have been charged with improper contact with a victim while confined, a third-degree felony. It appears that the agreement today is the state's recommending to the court that the charge be reduced to attempt to commit improper contact with the victim while confined, a state jail felony. We're also recommending that you be prosecuted under section 1244A of the Texas Penal Code, which means that you would be prosecuted as a state jail felon, but you would be punished as a misdemeanor offense of a Class A misdemeanor. It appears that the agreement is the sentence to be 365 days in the county jail with you receiving credit for 365 days of time served, a fine of $1,000, and the state's agreeing to abandon the enhancement paragraphs in the indictment. Mr. Ogletree, is that your understanding of the agreement and what you're asking the court to approve?
Yes, Your Honor.
Part of this agreement, you would also be required to pay reimbursement fees of $605 and court costs of $290. You understand that as well?
Yes, Your Honor.
Okay, all right. So Mr. Ogletree, at this time, I would ask you, how do you plead to attempt to commit improper contact with victim while confined?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir.
Court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulated evidence?
No objection as offered.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the victim in the underlying case, this particular charge does not have a victim by statute, but we did explain the situation to her as outlined in the stipulation of evidence, and she does understand the situation, and that's all the state has, Your Honor.
So is the victim supportive or unsupportive of the plea?
Neither, Your Honor. She just understands the situation for what it is.
Okay, thank you. All right, anything further from the defense?
Nothing from defense, rest and close.
All right, court's going to review the evidence. Reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court will follow the plea agreement. Court hereby convicts the defendant, Philip Andrew Ogletree, with attempt to commit improper contact with victim while confined, a state jail felony. The court will authorize prosecution and punishment under section 1244A of the Texas Penal Code. Court hereby sentences Mr. Ogletree to 1 year confinement in the Van Zandt County Jail, awards him 365 days credit towards that sentence for time already served, orders him to pay a $1,000 fine, $290 court costs, $605 in reimbursement fees. Court notes for the record that the state has abandoned the enhancement paragraphs in the indictment. All right, Mr. Ogletree, you're hereby remanded to the custody of the sheriff so we carry out the terms and conditions of the sentence. Once you are released from custody from TDC or the Van Zandt County Jail, then you are to report to the courthouse to make arrangements to pay your fines, costs, and fees. Failure to do so could result in a warrant being issued for your arrest.
Thank you, Your Honor.
You're welcome. All right, go over and see the deputy to be fingerprinted. All right, Mr. Manning, I'm going to sign these. If you'll go ahead and bring up your next client.
My last client is Mr. Spencer. He was literally walking in the door from TDCJ when I arrived today. He wishes to take advantage of the offer that was made to him, and we requested that paperwork to be drawn up by the state. I'm not sure as the status of that at this point in time.
Okay, so you just need a little reset, give it a little bit of time, recess rather than a reset.
But I'm not sure if they were going to be able to get that paperwork drawn up or not, but we have requested it to be done today.
Sure.
Miss Abney is working on it, Your Honor. She expects she can get it done, but there was an issue with getting jail time on some other cases. So she continues to run into those cases. Some of those took a couple of days for everything to come back. So she's trying to get that done, and if it can go smoothly, then absolutely we'll have it here pretty quick. If we could have 20 minutes, we should be able to have a final answer.
Absolutely, yes. All right, court will stand in recess until the state notifies the court.
Thank you, sir.
Thank you, Mr.
Thank you.
Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can lower your hand. Your name is Clayton James Spencer, is that correct?
Yes, sir.
And Mr. Spencer, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes, sir.
Do you have any questions about anything that you've read and signed that's part of your plea agreement?
No, sir.
All right. Mr. Manning, do you believe Mr. Spencer to be competent to enter into this agreement? And that if so, he's doing it intentionally, knowingly, and voluntarily after having been fully informed of his legal rights?
Judge, I believe he is competent. I believe he is entering into this plea intentionally, knowingly, and voluntarily.
All right, Mr. Spencer, I see that you are charged by indictment with a second-degree felony offense of burglary of a habitation that carries a range of punishment of not less than 2 years or more than 20 years in prison and a fine, if imposed, not to exceed $10,000. I see that the recommendation from the state in your agreement is that upon you pleading guilty, the state's recommending that your punishment be assessed at 3 years confinement in the Texas Department of Criminal Justice, with that sentence to run concurrent with your Coffin County case, which is identified as cause number 25-50440-489F. Mr. Spencer, you would also be entitled to credit time for any time that you've spent in jail. Mr. Manning, how much time is that currently?
Judge, after reviewing, we've agreed that there are 330 days credit time for this case.
So, Mr. Spencer, you would receive 330 days of credit towards your sentence for the time that you've been in jail on this case. In addition, you would be responsible for for court costs of $290 and reimbursement fees of $210. Mr. Spencer, is that your understanding of the plea agreement, what you're asking
Yes,
for?
sir.
Okay. All right, then, Mr. Spencer, I would ask you at this time, how do you plead to burglary of a habitation?
Guilty.
Are you pleading guilty because you are in fact guilty of committing that offense?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the stipulated evidence?
No objection as offered, Judge.
Evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance and no request for restitution was returned to the state.
Great, thank you, Mr. Harwell. Anything further from the defense?
Resting close, Judge.
All right, court is going to review the evidence at this time. All right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict the defendant of the offense. The court will follow the plea agreement today. The court convicts Clayton James Spencer of burglary of a habitation, a second-degree felony, assesses punishment at 3 years confinement in the Texas Department of Criminal Justice, orders that his sentence run concurrent with his Coffin County sentence as identified in this court's judgment. Further, the court assesses court costs of $290, reimbursements of $210, and the court awards Mr. Spencer 330 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Spencer, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you're released from TDC, if you've not paid off all of your court costs and fees, then you need to report to the courthouse and make a payment arrangement. Failure to do so could result in a warrant being issued for your arrest. Do you understand?
Yes, sir.
All right. Mr. Spencer, I'll have you step over to be fingerprinted. Thank you, Mr. Manning. Does that conclude our afternoon docket as far as your clients are concerned?
Judge, as far as I'm concerned, I believe that does.
All right. Anything further, Ms. Abraham?
No, Your Honor.
All right. Then court is adjourned.
Thank you, Judge.
Thank you.
Thank you, sir.
You're welcome. Have a good day.